WFLA Now will begin momentarily. WFLA Now will begin momentarily. Live from the Stream Center in Tampa, Florida. Top stories, breaking news, interactive coverage in the palm of your hand. This is WFLA Now, powered by 1-800-ASK-GARY. Here's JB Buno.
A hearing expected to culminate with key decisions in the Idaho murder trial. Bryan Kohberger is back in court today for a motions hearing that will set the stage for a jury trial later this year, or could it actually be next year? One of the many questions we're going to be getting to on this edition of WFLA Now. Welcome into the Stream Center, folks. JB here with you live across multiple platforms. Good afternoon or good morning, depending, of course, on where you are joining from. I'm not alone here on the stream. I want to get right to our featured guest because he's been hanging out in the Zoom room, being very patient for us. Peter Tragos. You know him because he's the lawyer you know. Peter, it's great to be back with you on stream.
Yeah, what's up, man? Happy to be here.
Yeah, great to link up with you once again. There's a good amount at stake today. This is a trial that people have been waiting really all year for. Of course, it was at the beginning of this year when Bryan Kohberger emerged as the murder suspect in the murders of the Idaho Four. You're going to see their pictures, of course, here on your screen, folks. What is the key thing that we might get decided today? Is it, in fact, going to be exactly when this trial is going to begin?
So that's one of the things on the docket, right, is the scheduling order, when things are due by, when they have to turn over expert discovery, when they have to give witness lists and exhibit lists. Those are things that are expected to be determined today during this hearing. But I think there are some more significant things at issue, like the stay and the alibi. And will this case actually stay on track at all, or will the court continue to grant stays for the defense as far as speedy trial goes? And if he continues to do that, then you might be right what you said off the top, that the trial might not be until next year.
As far as what we're going to be doing here on this live stream here today, folks, Peter and I are going to be going over some of the key questions. It's been many months since Peter and I have been on stream together on this story, and I want to pick his brain with what has developed in the last several months. But also, let me point this out. We are going to have, as we understand it, the hearing itself on this live stream. Now, again, because of Idaho court policy, their jurisdiction, and because of judicial policy there, we cannot live stream the hearing, even though it's, of course, it began at 10:30 Pacific time. That's, of course, 1:30 Eastern. And so we're in that window right now. But, Peter, we can't live stream it because of court policy. People want to be in that courtroom, want to watch it virtually, watch it here on YouTube or WFLA.com, but they can't, and we don't expect that to change, of course, for the trial itself, correct?
Usually they stick with it or maybe even restrict it more once the case goes to trial. The most recent high-profile murder case in Idaho, Lori Vallow, they had cameras and microphones in the courtroom throughout the pre-trial phase, and then for the trial, they removed them altogether and released the audio after the trial day was complete, sometimes even a day later. It's kind of similar to what they're doing now. They're not waiting a full day, but the hearing will happen now. Once it's complete, then the video and audio is being released, as far as I understand it, to people like you, so they can publish it and the world can see it if the public has interest in this hearing, which I think they do.
Yeah, so we have the live feed tapped into the Stream Center here, folks. In fact, welcome in to the WFLA Now Stream Center. Peter has been with us here before in person. He's here in the Tampa Bay area, but he's joining us virtually here today for the next half an hour or so, because right now, this is actually going on in Idaho, the motions hearing, and we're going to be following some of the updates from some of the reporters that are inside that courtroom right now. But this video that you are seeing here on your screen between Peter and I, this is, of course, from previous hearings, as far as some of the sampling of video you're going to see rotate through on your screen. Again, as soon as the hearing itself is over, a ping is going to go out to media stations, news stations across the country to begin receiving that feed. That exact feed that's coming out from the pool camera feed from Idaho, we are going to share with you here live on stream. So you will be watching it all unfold as news stations across the country do. We're literally tapping into that same signal, but we can't tap into that signal. They cannot begin the court feed out until the hearing is done per court policy. So we'll be following along, doing a little bit of play-by-play here. Peter, already we're seeing some tweets come out. What are you paying attention to at this hour?
Yeah, I've got Twitter up. I haven't really seen much come out except for what we expect to be decided today. Again, what DNA information, the IgG, we've seen declarations from experts filed by the defense. Will the state have to turn that over? And what's interesting about every one of these motions to compel discovery that the defense has to file because the state is refusing to give it over. And in this situation, they even filed the state a motion for protective order for this information. So every time this argument happens, if the state ends up having to turn it over, it's another bullet in the chamber for the defense to say they're prohibiting our ability to prepare this case for trial within the speedy trial period and therefore violating Bryan Kohberger's speedy trial rights. They've already made that argument in a few motions. We're also going to determine if the court is going to compel Bryan Kohberger and his team to produce more details around the alibi, or if he's not going to allow them to use an alibi at trial. I would be very surprised if that happened. Or a very unusual situation, which I've actually never heard of in my career, the defendant having an ex parte discussion with the judge, discussing his alibi and potentially talking to the judge about the different strategies they may have in trial. That was kind of mentioned in one of these motions. So a lot on the table in today's hearing. I think it's going to be a really interesting hearing to watch once they release the footage.
Are you saying that, based, of course, on the paperwork that we're getting out of Idaho, that there could be something between Kohberger and the judge in this case? Is that what you're saying? I want to explain that last part for our audience just joining us. And Peter, I think I have you frozen, or you're just staring intently at me. I'm not entirely sure, but I believe that that things have froze on Zoom. Peter, you still have me?
Yeah, I must be frozen though.
Yeah, I think that you are, and I'm not sure if that's on your end or our end. It's always hard to tell on Zoom. In fact, I'll just kind of wiggle the mouse here and see if we have any signal indicators. Are you with me now? Peter, we'll you know what? We'll come back to you here in a little bit, and hopefully we can get the signal fixed. Again, apologies for the technical difficulty, folks. There's been a bit of a freeze, and I believe that I lost Peter, but I'm not sure if I lost our audience. Hopefully everybody can still hear me okay. We're going to be following, again, some of what's going on right now. But again, this is to cover a motions hearing in Idaho. And I'm reading through some of your comments. As always here on stream, you can use #KJB if you would like to interact with us. And I think Peter is now back. Let's see if we can bring Peter back on here. Peter, do you have me?
Because you're looking fine on my end.
Let's reset.
All right. So the alibi.
Yep.
So the state demanded Kohberger share his alibi. First time they gave kind of a vague answer saying the alibi will come if Kohberger wants to testify through expert witnesses, through cross-examination. The judge has discretion to disallow any witnesses or any argument about an alibi if you don't present it in time under the rules. So the state said that's not good enough. They filed a motion to compel an alibi and the supporting materials and witnesses and phone numbers and contact information so the state can refute that alibi. Well, on the second motion, the defense said Kohberger was out driving by himself as he had a habit of doing. Again, seemingly something Bryan Kohberger would testify to. But they say it will be corroborated by expert witnesses and potentially cross-examination of the state's witnesses. That could be with cell phone data, cameras, CCTV, whatever it may be to corroborate where he was and where he was driving. And the defense also said they don't need to provide this information to the state in its entirety or any more than they already have, because it could affect certain strategy decisions on how the defense wants to handle the case. Additionally, they complained that the state is not even providing all the discovery the defense is entitled to, and therefore they can't answer these questions until they have this discovery. They went as far as to say, Judge, if you think we're lying or you think we're bluffing, we're willing to have an ex parte hearing, meaning a meeting where the state is not there and Bryan Kohberger can tell you, Judge, here's where I was, here's what I was doing, here's what we need to prove that. And then again, he's not waiving his Fifth Amendment right to testify, but potentially the judge can listen to this and say, okay, I'm not going to disallow them from calling witnesses or making this alibi argument. I'll allow it. State, you've got to turn this stuff over.
And if that ex parte hearing, if that were to occur, who would be there? Who would be present?
Usually just defense counsel, the defendant, and the judge.
That's it.
Potentially a court reporter, but it would be sealed. It would not be something the public would have access to.
Now, we all have watched, crime shows and Law and Order and insert, true crime show here. Does that happen inside the courtroom or does that happen behind closed doors in the judge's office, so to speak?
So they can either be in chambers or in the courtroom because it's the defendant who, is in custody and cuffed most of the time when he comes in, and bailiffs. They could just have it in a closed courtroom if they wanted to. It really is just judicial discretion.
Very interesting. We'll be following along here, and I'm following Alex Capriello, who is a correspondent for NewsNation, and I'm going to be reading some of his tweets here to kind of get everybody caught up and kind of up to speed. 17 minutes ago, saying the defense says that they are well-versed in criminal defense and DNA genealogy. They will not be called as witnesses if this goes to trial, but are critical today when discussing DNA evidence and why it should be allowed into discovery for the defense's preparation of the case. Peter, how key is that DNA evidence being entered? We know it'll play a role at some point at trial, correct? I mean, that's pretty much a virtual certainty at this point. But as far as it being, or is it? No, correct me if I'm wrong.
Potentially. DNA evidence is going to be really important at trial. Yes, you're 100% right about that. What they're arguing about getting?
Right.
Probably not, which is kind of like how they preserved the testing and what they used and what systems they searched to connect Kohberger's dad. Once they got his swab, probably going to be enough to connect it to the touch DNA to be using it at trial. But if they can, win these battles and get information to show the state did something wrong or the law enforcement did something wrong and potentially fruit of the poisonous tree, they never should have gotten to Bryan Kohberger, throw the whole thing out. It could happen. It's really unlikely, but I really don't know if this is going to be the thing that affects the DNA presented at trial.
But it being granted in discovery, how consequential is that?
It depends on what they find. If law enforcement did nothing wrong, it's not going to be consequential at all. But if these experts or people they have look at it show that law enforcement bypassed the rules, planted DNA, planted evidence, found out Kohberger was the guy and did whatever they could to connect him to the situation, then obviously it could be a big deal. It really depends on what they find.
Very interesting. Alex tweeting out a moment ago, the judge saying, quote, "There has to be some level of trust in discovery. You are all sworn attorneys. Mr. Thompson is saying that there is one more lab report coming your way." And then he follows up, the judge is asking prosecution to reach back out to the lab and make sure there are no other existing documents and results that the defense does not have. Defense is adamant that the prosecution has given everything that they have and calls the pleas for more information speculation. So a little bit of the back and forth exchanges now. And look, folks, we're going to hear all this play out when they do, in fact, share out the feed at the conclusion of the hearing. That's why it could be viewed as silly that we're not just able to hear this live and we're able to follow the tweets. We're going to have it in a matter of hours or less than that. What do you make of this back and forth exchange that's going on right now, Peter?
So, I mean, one of the interesting aspects of this is the state says you have everything. We've turned everything over. The defense is like, that's impossible. And they've even produced some experts and, affidavits that have said other documents and materials have to exist if you went through this process. So the judge, I think, based on those tweets, is saying, listen, if the state's saying they gave you everything they have, there has to be some level of trust there. We can't say produce something that doesn't exist. They say there's one more lab report. Maybe that's going to have the answers you were looking for. So wait till they produce that lab report, and then we can kind of reconvene and see, are there still things you're missing? And if the state says they don't have them, there's nothing really a judge can do to compel a state to turn over something they don't have. So that's part of the argument here, that there does have to be some level of trust in this process, which is why all of our bar cards and livelihoods and a profession of ethics are on the line every time we litigate a case.
We just have a tweet in from Alex a moment ago saying that the defense has called their first witness by the name of Stephen Mercer. Alex notes that there was a brief pause in the proceedings to excuse the other witnesses that are going to be expected to testify today. Mercer is from Maryland. He's a licensed attorney in Washington, D.C., in the field of criminal defense with a specialization in DNA. Is the defense conceding here that this DNA evidence is going to be perhaps the most significant evidence when this does in fact go to trial? The fact that this is being discussed pre-trial in these motion hearings so much, and it's being some of the methodology behind the obtaining the DNA has been so widely discussed and now is really the subject of this motions hearing, Peter. Is that the defense saying, my goodness, we are trying to do everything that we can to throw this out?
So there's a couple different ways to look at it, right? If this is something the state wants to hide, the defense has said in some motions, then that makes it more significant to them. If they believe that this is something that could kind of nuke the whole case, then that's going to make it significant to them. I don't think we need the defense to tell us that the touch DNA on the knife sheath is going to be one of the most important parts of this case. I just don't think that the discovery they're seeking for is going to really be the thing that attacks that touch DNA. I think they're going to have to do that other ways, how it can be transferred, how easily it can move from one object to the next, how law enforcement could have even inadvertently done this, whatever it may be. There's a number of different arguments against the touch DNA. I'm not so sure that this compulsion of discovery is the same argument as that, but I think at this point, it's just something the state keeps objecting to, files a motion for protective order, and the defense absolutely believes that they're entitled to it. And I think they would do that on any piece of evidence in this case, not just something that they would call the most significant piece of evidence, because that's what defense attorneys do in cases like this. Any opportunity they can to find something good for their client or that would have a beneficial outcome for their client, they're going to do it.
Of course. And they're going to explore, Bryan Kohberger is going to explore every legal option that he has, any legal strategy that he has to poke holes in the prosecution's case, of course. Peter, we're going to start to get to your hashtag HeyJB, hashtag lawyer, questions and comments, folks, as we kind of do a little bit of play-by-play and waiting for the feed to be transmitted our way to the Stream Center so that we can share it on stream with you, the actual court hearing itself, but we can't do that until the court hearing concludes. Peter, I want to circle back to one other thing. Before we go to the questions, I want to circle back to one thing that we were talking about as we were getting our technical difficulties there on Zoom. The alibi. The alibi comes out. We haven't been on stream. We haven't talked about the alibi since it has come out. The alibi, really, in essence, Bryan Kohberger indicating through the paperwork that we all obtained that he was just simply just driving around. What is the legal analysis of that alibi? And additionally, will that have to be demonstrated in trial, that this was somebody who would just casually just drive around in his car? The alibi didn't state that he was running an errand or going to pick something up or visit somebody. It just, in essence, stated that he was driving around. Is that something that will have to be proven? And what is the legal analysis overall of the alibi?
So the evidence has to at least infer something that the defense would argue. So that would mean if there is evidence of cell phone data or car movement, black box data from the cameras that he would drive around at night, that could be enough to quote unquote argue or prove this alibi. If he testifies, that's obviously evidence of this alibi. Now, how reliable is it? The jury will have to determine that, but that would be corroborating evidence as well. They don't have to prove that this was a habit and something he did all the time. This could have coincidentally been the only night that he drove around late at night and went for a drive. Now, what's interesting about that is when this first came out, and I talked about it on my YouTube channel, a lot of people in the chat said, I go on drives late at night. That's possible. I don't think it's the most impossible thing. And so maybe your chat can chime in here as they're watching if that's something that they do or know anybody that does it. But more importantly, one of the interesting parts about an alibi like this is it does actually fit with some of the inarguable evidence the state has that he was in a car driving around, potentially without his cell phone late at night. And they may have other evidence of what they're calling, or what some people in the media are calling, casing the joint, where he would drive similar patterns days before and in the months before the crimes occurred. So maybe he's going to use that as the habit evidence that, look, I used to do this all the time. No murders occurred when I did it on this night or that night or whatever. I just do this to clear my mind. That's a potential way we could see the argument coming out, but he doesn't necessarily have to do it that way.
You know, I might ask a poll question, and I'm just curious as to how many people just go for drives anymore. And I know that it's not a scientific poll. It's not. It doesn't inform us to all that much. But just, I'm a reporter. I'm curious by nature, and I can assure people that look. I don't really just go for drives. Peter, do you just get in your car and drive around just for driving, just because
Absolutely
you enjoy
not.
being in your car?
That's not something that's interesting or clears my head. No, I mean, I see people go out for a run or go play a sport of some sort or go sit in the pool or the hot tub or something like that and clear your mind that way. I'm not a drive guy like late at night, but I know there are people that are. And I think a poll is interesting because regardless of if it's scientific or not, it is at least a cross section of our community and communities around the world. And that's what a jury is at the end of the day. So if half the jury is like, yeah, I go on drives all the time, at least they're not going to think it's completely out of order or out of turn for somebody to do that. But if nobody thinks that that's normal, that's obviously a bigger problem when this is your alibi defense.
I'm just putting this in our YouTube chat, just because I'm curious. I'm just curious. Do people just casually go for drives anymore? And if you're joining us on YouTube Live, you'll see the poll that'll animate in our comment section. Do you ever just, some people might have a purpose behind it, such as, clearing your head. Sometimes going for a ride will just allow you to kind of get in a different headspace or get a change of scenery. But I'll share for our audience. I can't remember the last time that I just went for a drive just to drive around. But that's just me, and that doesn't have any legal consequence here. It's just a matter of me being a curious live streamer, a curious reporter here with, again, Peter Tragos, the lawyer who's joining us here on stream. Folks, we're going to start to animate your comments using hashtag HeyJB and hashtag lawyer for the next 15 minutes while we have Peter on stream, because Peter will be doing his own live stream on his channel, the lawyer and he's going to be doing, of course, a real deep dive into the legal analysis of what is unfolding today in Idaho. So let's start to get to some of those questions here. I see people that are using hashtag HeyJB or hashtag lawyer in the meantime, really quick, as people punch those comments in, Alex, his most recent tweets, Stephen Mercer, who is testifying, he's an expert, says he's not here to discuss Idaho's discovery rules or offer legal opinions, but rather focus on his expertise in forensic DNA interpretation. His quote, who must comply with their duty to investigate. According to Mercer, he says it's essential for the attorneys to know about the details of the testing and the investigation of DNA evidence. There are pretrial concerns involving suppression and Fourth Amendment issues, again, according to Alex's tweet. So that's the latest. We're going to hear it all when we actually get the courtroom feed. But in the meantime, let's look for some of the questions. Beth wants to know. Oh, hold on, Beth. We'll get your comment up here on screen. It's just taking a minute because all of a sudden they're scrolling in very, very fast in the stream center. I'm trying to get to as many as I can. Let's see. It'll pop up here. But Beth is saying, is this a stall tactic? Is there anything here where Kohberger and his attorneys could be viewed as could this be a means of stalling, Peter?
So the only way a stall tactic works in a situation like this is if the judge grants something, because if they lose all of these motion hearings and they lose all of these arguments and motions to compel, and the judge says you're not entitled to this evidence, then it didn't stall the case. They're still within their 6-month and 37 days now that one stay has been granted. They're still on that timeline. They're still within that time period. So the defense can't really forcibly stall the case here. But if they prove that the state is stalling the case, then it has some potential repercussions when it comes to the defendant's speedy trial right. And I think that's why they're continuing to ask for motions to stay so that they can get more time. And they're saying, again, it's because the state is delaying. The state is not turning over evidence that they need to present this case. So the defense can't really control how slow evidence is moving back and forth, because as we know, the state has the vast majority of the evidence in every case, especially this case, and the defense is stuck within their 6-month timeline.
And what is your expectation, Peter, as far as I pop back on camera here? You and I, the last time we were on stream together, I forget the number that you put it at, but you pretty much said it was just not very likely that we had an October trial, and we might find out today exactly when a trial could be slated to begin, whether or not there is going to be a delay. What's your expectation?
I think that 37 days was a pretty big decision, and I think that I don't know if the camera's on the right thing. There we go.
There we go.
So I don't know that it's going to happen in October. I would say it's still a very, very, very slim chance. I think that 37 days was important, and I think there's a higher chance it happens between October and December of 2023. If the court will grant some more short stays potentially. But I still think most likely is it's going to get continued out, and it's not going to be something that happens within a speedy trial period. That's kind of how I felt the entire time. But I think as long as the court gives some small extensions, every time something like that is given, I think it's more likely that the trial happens within this period.
Let's go to Angie's question. Wants to know, are they keeping him isolated in jail? What do we know, Peter, about Bryan's stay there in Idaho as far as him being locked up?
I don't know the answer to this. I think I remember reading somewhere that he was, but I honestly am not positive.
Yeah, I mean, well, let me ask you this question: how often do you think he's meeting with his attorney? What would be standard? I mean, how in a situation like this, high profile murder trial is expected to happen later this year or in the months ahead. How often would it be, sort of normal for someone like Bryan Kohberger to be meeting with his attorney?
So this high profile case is unusual, but in a case that is high profile that they're trying to, at least purporting to try to get the case tried within 6 months, at the very least, they'd be meeting weekly, probably multiple times a week. If you base it off of the number of motions that are filed, the number of hearings they're having, the number of affidavits they're having, and meeting with expert witnesses. Now, they can be working on the case and preparing these motions and prepping for these hearings without necessarily meeting with Bryan Kohberger. But it seems like this case is basically all these attorneys have been working on since starting for Bryan Kohberger.
Yeah. Well, so much has been talked about online and on channels such as yours and in your comment section about what the defense strategy could be like, what those conversations are going to be like. Of course, we might get a bit of an inside look as to some of the Mercer right now is on the stand. He's being questioned. We'll be able to hear some of that and some of the questions that are being asked during testimony today. Once we do have the live feed. I mean, that's, I guess, again, why we are here live, folks, is to tap into Peter's expertise, but also to let you know that we are going to be live streaming the press pool feed as it's being transmitted out of the courtroom there at the conclusion of this hearing. Let's go to some other questions that we have here in the comments section while we have another 5 to 10 minutes with Peter Tragos, the lawyer you know. Yeah, some of these questions are very, speculative, like, did he do it? And that's, of course, why we have a judicial system. Peter knows. I mean, Peter, how often do you get a question like, oh, do you think Bryan's guilty? And then you just can't answer that question.
I have no idea at this point, right? I mean, that's the point of the process, the point of the system, the point of why they've got to turn over discovery, why they've got to share alibis so we can try to get down to the bottom of it. And at the end of the day, everyday lay people are going to make that decision. Did he do it based on all the evidence that's presented to them? I mean, he's presumed innocent right now. That doesn't mean he didn't do it. It just means as we look at it now, it has not been proven.
Yeah, I mean, this is why people watch court cases online on YouTube. I mean, this is why, I mean, they want to ascertain for themselves and in essence put themselves in the jury. And if you're there to, I mean, you can't ever be in that courtroom. It's not the same as actually being there, but being able to listen to the evidence get presented, being able to have discussions with your fellow commenters and to hear the expertise of somebody like Peter, that's part of how this all works now in 2023. People like to follow these trials to ascertain for themselves and form their own opinion as to whether or not they believe someone is guilty or not guilty. But maybe we can pivot to this question from Ali or Ali, either one of the two, hashtags for us both. Do their lawyers know if Bryan is innocent or guilty? This is a question that people wonder about. The reality of the conversations that take place between a client and who they hire to represent them.
So what I'll say is his lawyers know what Bryan Kohberger is telling them, right? So if he admits that he did it, then they know it. If he says he didn't do it, then that's what they know at this point. Regardless of where the evidence points them, if your client said you didn't do it, that's usually what you go on. Now, a lot of times when a criminal defendant may admit guilt to their defense lawyer, some defense lawyers state prove that case beyond a reasonable doubt. And the state still has a burden to prove the case beyond a reasonable doubt, regardless of what a criminal defendant tells their criminal defense attorney. Because if the state violated the criminal defendant's rights, then they still might lose the trial, even if they have the right guy, as people say, because rights are important and those rules have to be followed. And you can't just trample on constitutional rights of the citizens of the United States. That's how it's written. That's how it's set up.
Yeah. And it's the foundation of our judicial system. I mean, that's exactly the rules, of course. Policies have to be followed, and they can vary, of course, from jurisdiction to jurisdiction, state to state. Peter, I'm sure I've had to do homework as best I can. I'm sure you, focusing on the law, you've really had to about the particulars, some of the nuances when it comes to the Idaho judicial system.
Mm-hmm. Yeah, and the alibi is one of them. You know, they demand an alibi there. You've got to provide it with a certain number of days. The preliminary hearing versus the grand jury indictment. We spoke about that a lot during this, early phase of the case, how it seemed like it was going preliminary hearing. Then it went grand jury indictment. The defense has filed some objections and taken issue with that, but that's the process in Idaho, and that's how it's allowed to happen in Idaho. There was nothing wrong or improper about the state doing it that way. I know some people online feel like it might be shady or they wanted to hide the process, but all grand jury indictments are secret, and people don't get to be in that process and see how it happens. So I don't really have a big issue with that.
Destiny wants to know for us both, can they do a lie detector test on him? This is a question that we get all the time, is whether or not lie detector technology can be used, and it's not a simple sort of question to answer. But here, do your best there, Peter.
So the answer is they can, and if you mean his lawyers, they can do a lie detector test on him if he wants to submit to it, if they want to use it and see whether or not they believe what he's saying or test his credibility or see how he comes off as far as reliability goes. There's no jurisdiction I'm aware of in the United States where lie detector tests are admissible evidence in court. There's a number of reasons for that, but basically their reliability can't be tested well enough. And some people have been known to be able to beat lie detector tests. And then you don't want jurors to put too much weight on something that can be beaten just in case it was beaten. So therefore, the defendant just takes a stand if he wants to testify, talks to the jury, and the jury determines whether or not they find him credible and if they believe what he's saying or not. So his lawyers can put him under lie detector test if he wants to submit to that and try to help prove he's telling the truth to his lawyers, but it's not going to be something that's used at trial.
Yeah, it's not a 100% foolproof technology, folks. I mean, people forget that. They think that it's going to be an automatic, oh my God, this person is guilty or not guilty. But there are many ways it can be fooled. There can be problems with the technology as well. And while we do hear about it a lot in movies and TV shows, actually how it's deployed and used, it just doesn't give you 100% certainty. Destiny, thanks for the question here. Let's go to my bet, because it brings up a great point. If he has an alibi, why wouldn't he plead not guilty? Didn't the judge have to plead for him? And this is a good question, because again, let's remind, he decided to stand silent, which means that the judge in this case entered a plea of not guilty for him. So to this question, if he has this alibi, why exactly wouldn't he just enter a plea of not guilty, in your opinion, Peter?
So it's a good question by my bet, and it's really something that, if we want to think logically about this, makes sense. If you didn't do it and you want to say you didn't do it, why don't you stand up in court and say, I didn't do it, I'm not guilty? But when we come to legal procedure, if there are reasons and ways to do something that have the same outcome, but you believe or your lawyer believe it protects rights in another area, then you're going to go with that. Because the way that they did it standing silent, his lawyers have filed in other motions that they felt it preserved certain rights in the grand jury process, and objecting to that grand jury process. By standing silent, they were able to preserve those rights while also having the same exact effect legally as pleading not guilty in this situation that you were saying. He's still saying he didn't do it. He's still saying he has an alibi and therefore he's not guilty, but he did it with the judge's words instead of his own in order to preserve another right that, whether I agree or disagree with that second part, doesn't really matter. That's why I believe Bryan Kohberger did it in this situation, is it had the same legal effect by standing silent as if he would have said it with his own mouth that he was not guilty.
Yep, and of course he had his own legal reasons for doing so, and we still don't know if that was upon the recommendation of counsel or if that was his decision to stand silent. Of course, much has been made of that particular decision. Peter, we're going to let you go. Of course, I promised I would get you out of here at 2:30, so you're going to be live on your channel. We appreciate your time being able to lend us your expertise, folks. If you want to, of course, follow Peter Tragos, you can do so. He is known as the lawyer you know across his social media platforms, including now Twitter/X, I think we can call it. Twitter/
whatever it's called.
Yeah, whatever Elon's calling it this week. You can find Peter at lawyer you know. Peter, I'll get you out on this really quickly. Multiple witnesses, multiple experts are expected to testify here today. We do have the time zone difference, but how long do we? I asked you this by text. You and I were texting before the stream. I mean, we have heard the same thing about the expectation that this hearing is going to be somewhere in the 60 to 90 minute range. But if these exchanges go on in court for a long time, is there any chance that this goes on all day, or even, my goodness, into next week? Is that even remotely on the table? And I think we froze on you, Peter, again, if you still have me.
I think we're good now. So I think the judge would do everything he could to finish this tonight, even if they have to stay late or cut off how many experts they can call, or maybe make them shorten some of the expert witnesses. I think it's going to take a couple of hours now, because I think it could have been limited if the state would have agreed to certain things, or, yeah, we're going to turn over this DNA stuff, not that. But it seems like there's not much they've agreed to since the last time they spoke. We're going to have to hear from the expert witnesses. The judge is going to have to make a call after both sides make arguments. So I expect it's going to last a couple hours, but I would guess it's going to finish tonight. There's no guarantees, though.
You know how I know you're good at what you do? Even when you're frozen, it's not one of those really awkward faces where you have one eye open and one eye closed and you look all blurry and everything. Even when you freeze on me, you're still looking as sharp as ever. Peter Tragos.
I work on that specifically,
Peter Tragos, the lawyer you know, friend of the program and total pro here in the Tampa Bay area. Peter, thanks a whole lot. You and I will be texting, I'm sure, and we'll be talking about this as the day unfolds.
Yeah, man. Thanks for having me.
Yes, no, thank you for coming on. And folks, again, the lawyer you know, you can follow him on his respective channels. Peter's always great to have on the program. Back here with you live on stream, JV Buno here with you in the WFLA Now Stream Center. Again, we are awaiting the feed. I have all of these screens here in the Stream Center for the purpose of being able to punch up and calibrate the shot from Idaho. What is going to happen is the hearing is going to play out today. Right now, they're doing an expert testimony. This is something that began at 10:30 Pacific time. And of course, 1:30 Eastern. It's going to play out for however long it's going to play out. Again, Peter and I heard about 60 to 90 minutes. But if this goes on for a couple of hours, that'll delay, of course, when we can actually begin distributing the feed to you. We're going to have it here on this live stream, the exact feed out of the courthouse from the pool camera team. We'll be able to share that, but we cannot begin transmitting or live streaming that signal until, of course, the hearing concludes. So we're all just kind of following some of the reporters on social media, on Twitter. Yeah, I'm still calling it Twitter because it's weird calling it X. X just sounds weird, you guys. It does. I'm trying to do my best to get into it, but it's just weird to say we're following along on X. It just doesn't sound right. It doesn't roll off the tongue like Twitter did for so many years. But we're going to, of course, follow the play-by-play with some of the reporters, including Alex, who, again, is with NewsNation, and he's live tweeting this. My goodness, thank God that we have we wouldn't really have much to go by if phones were banned from this courtroom, like in many federal courthouses. Usually reporters are not allowed to bring in their phones. Here in Idaho, they can bring their phones into the courtroom. So, of course, they are able to live tweet, and we're following a lot of those tweets as they unfold. But really, this is just a place for us to answer some questions. I'll do as much play-by-play as I can. I might have to pop off stream or at least mute microphones because we do have other stream programming that we are likely going to be providing today for WFLA.com. So there's a chance where we might take a break at some point, but stay with you up here live on stream, of course. And I'll do my very best to answer questions as we await the conclusion of this hearing so that we can watch it all unfold live, or at least as live, semi-live. Let's see here. Looking at some of the tweets. Oh, Alex had to step out for a live shot on NewsNation. So he's hoping that the bailiff will let him back in. I would hope that the bailiff would let him back in. That's part of the. I mean, reporters come and go from courthouses all the time. Hopefully, they'll understand that he's just trying to do his job. So, really quickly, folks, let me just check in here with our team for 1 second, and then we'll start going back to the comment section and answer some of the questions that you have. Stand by. I almost forgot about the poll, you guys. The poll question. The alibi that comes forth that Bryan Kohberger says he was just driving around. Of course, this goes back to some of the cell phone pings that investigators say that they have, digital evidence that he was in the area, of course, driving around around the time of the murders of the 4 students at the University of Idaho in Moscow. And so we were just informally, casually asking you as to whether or not you casually go for drives anymore. I can share that I can't remember the last time I just went for a drive. I'm trying to think of like the last time that I did that. And it's just not something that usually when I'm in my car, it's because I need to go somewhere, or pick up somebody, or see somebody, or run to the grocery store, or go to work, or see a friend, or whatever it may be. But some people will just go for a ride. And I'm going to ask everybody just a little bit, just again, while we're awaiting Alex returning to the courtroom, is while we're waiting for the live, or really waiting for the hearing itself to be over so that we can get a look inside. people can share a little bit. And now the one comment that I saw that people were saying is, my goodness. We'll go to this hashtag AJB comment from S. Hicks saying, what broke college student goes for long drives in an old car when gas is almost $4 a gallon? What is the price of gas in Idaho? Or I guess it's not very relevant now. It's really whatever the price of gas was in Idaho going back to really almost a year ago now. But just for, gas is about $4. Just say about $4 a gallon in Idaho. It's not like the good old days of, $2 or so. It's just, it's more expensive to just kind of drive around. But S. Hicks brings up a really good question. If that is your alibi, that's your alibi. You say, and look, everyone has the right, of course, to defend themselves legally and provide their version of events in contrast to what the prosecution is saying that you did. If you're saying that you were just casually driving around, people would wonder, it's only natural to wonder, why are you riding around in, late at night when gas is expensive, when most people are sleeping, and most college students, if they are up that late, they're either, having a good time or studying, like at the library. Let's go to the poll results. We asked a very casual poll about casual driving. And we casually asked with our casual poll, do you casually go for drives just to enjoy driving? 43% said yes. 57% of people say no. That is crazy to me. Just because I usually have a pretty good grasp on where I wasn't expecting it to be that high. That means that more than 4 out of 10 people just say that they'll just casually go for drives, just to drive. I have our meteorologist here, Rebecca, Jeff. Do you guys just drive around ever? Just to drive? No, you're on the phone. I'm sorry. Jeff, no. So nobody in this room ever just kind of casually goes for a drive. But that's the alibi that we have from the man right here on the right side of your screen, Bryan Kohberger. Again, this video dated. We do not have the live feed yet, or the feed from the courthouse, the feed from the courtroom. But this is the first time we've been on stream since his alibi has come to light, and it's worth a discussion as we're awaiting the conclusion of this, this motions hearing. And, there's so many different parts, components to this case, from, of course, the DNA to the sheath, to Bryan being apprehended, to some of the reports that have come out about family members, the digital evidence, the cell phone pings. There's the vehicle. There's a lot of different threads to this case, and now we have the alibi. Just kind of driving around late at night. And to Peter's point, is there, and can it be demonstrated that there was, or if there was, a evidence that this was a routine behavior, that this is something that he did often, and that this wasn't. But even if it wasn't part of his routine, it is still the alibi that we have. Did he just feel like going for a drive that night? Did he? Would he say something to the effect of, "My goodness, I had a lot on my mind. Every now and again, I like to clear my head for driving around Idaho. Or again, crossing the state line, going into Idaho." And this is why, folks. This is why I am unapologetically an advocate for cameras in court. And yeah, it's for obvious reasons, but I'm like one of you. I don't want to watch this recorded. I want to watch this live. We're all gonna if you're here right now and you're invested in this case and you're waiting for the feed just like I am, you're gonna watch it at some point. So what is the argument for the video feed not being streamable? Why can't it be fed out live? So many other court cases have been. If your argument is that the video, just cameras aren't allowed in the courtroom, that's a whole other thing. A whole other argument. It's completely different. But there are cameras in this courtroom. They're there. They're recording it. And then as soon as the hearing is done, it's going to get streamed out here on the internet, and it's going to be available on every social media platform, including YouTube, right here on YouTube. So I struggle to find the difference as to why it just can't be streamed. If it's going to be transmitted, and if we're going to be able to watch it in its entirety, what difference does it make if we're watching it live versus an hour and a half to 2 hours later? So I would love, and look, I'll share with you. I don't think I've ever said this to anybody before, but I have attempted to talk with judges about this in Florida. I'm a reporter in the state of Florida, and I have made attempts to speak with Florida judges about their positions on cameras being allowed in court and the concept of it being live streamed, a case being live streamed. And I can't break through on that front. I still, judges don't like talking to reporters. They don't. But it's just that's how it is. It's the way of the world. But I have attempted to have conversations, not even conversations, just more email exchanges, just trying to, I guess, get clarification on court policy. It's not like I'm running into, a Florida judge at my local diner to ask him or her why. I have shot emails to judges in the past, just seeking clarification on the court policy. It's my job to ask questions for a living, and every now and again, I will ask a judge, just why is this law or why is this policy the way that it is? Is there a certain reason? Just for us having a better understanding of the law, of judicial policy, and I have never really been able to get an answer on that front. The answer that I usually get, whether it's from the judge themselves or from a clerk, it's usually that's just the way it is. So some cases, yeah, you get streamed video, live video. Johnny Depp, Amber Heard, live video. Now that was different. That was a lawsuit. That was a civil case. But of course, and there's very much a massive difference when it comes to, crimes that are committed, felony, or in this case, a murder trial versus, let's say, a civil lawsuit. Two parties who are civilly, or a party who is civilly suing the other. But yeah, I would just like for someone's got to be talking about it. Somebody has to have the conversation about why certain cases can be live streamed and others can't. The last time we were on stream having this conversation was with the former president of the United States. People who want to be there or be in to be in the courtroom virtually for one of the upcoming Trump trials, and people seeking clarification on whether or not the judge would allow, and that became, of course, politically charged the moment that you start asking, oh my God, would the former president of the United States be in court for a live stream trial? That of course, political questions were getting asked left and right. But look, is there ever going to be any set of standards when it comes to how technology has evolved and how we have access to these. Should you have access to every trial ever? Maybe not all of them. If there's a trial where there is confidential information, if that could threaten, maybe jeopardize, national security. If there's a trial where minors are present, there are certain criteria, certain circumstances where maybe a judge would not want the trial to be streamed. But in this case, with a murder trial like this, people want this to be streamed. And I'm going to be completely honest with you. I don't blame people for wanting the trial to be streamed, because if it just so happened to be in a different state, the rules might have been different. We might be able to follow it all live, but in this case, we can't. So here we are. Yeah, people bringing up O.J. Simpson. My goodness, that's like that's a quintessential example of how a trial can play out publicly. So that's my spiel about live streams in court. I know I can go on for a long time about that, but really the reason is simply because I'm trying to learn more about why the rules are the way that they are. I'm inquisitive by nature, and I just want to know. Okay, let's check back in with Twitter. See what Alex is tweeting. And the reason I keep going back to Alex is, of course, we are very much aligned. We're allies, if you will, in the news business with NewsNation. We are all under the same company umbrella. And so I'm trying to find out. Alex says he's trying to get back in the courtroom. Says working on it. Oh no. Idaho, let him in. He's just a reporter trying to do his job. He had to step out to be on TV. In the meantime, let's go back to the comment section and try our very best. Lazy in our comment section says the court TV is live streaming it. That can't be. No, I don't think that's permissible. All of a sudden I can't get through to that channel. Try on my phone. The primary reporter that I would be using for play-by-play to find out what's happening in court is not in court at the moment, and we don't have the feed. So, no, I am not seeing any live feed of, and as I understand it, they would be in strict violation of Idaho judicial policy, the court procedures in place. But no, it's not on court TV. So somebody said that, and I just wanted to make sure, because that would be that would be that would be a distraction, because then all of a sudden it becomes about how court policy was violated, and it becomes less about the actual what's actually occurring in court. I'm very grateful that we're starting to get some comments in about people explaining why they would just kind of go out for a drive. Gas is expensive. Now, if you had an electric car, you could make the argument that, look, I don't have to spend money on gas. I just charge, and it's way more affordable than driving around. But Carrie says, look, driving around is cheaper than going to a bar, relax, or no, sorry, excuse me. Driving around is cheaper than going to a bar. You can relax, you can play music, you can sing. Yeah, you can be in your own space. Again, we were asking very casually about why people would just kind of go for a drive late at night. And I do remember when I was younger. I remember a few times I would go out just to drive, but that was also because, like every 17-year-old with a car, for the first time, being able just driving around and being in your car and just going for drives was such a new thing. And you had waited obviously for so long to be able to just drive anywhere yourself. So just going for a drive was very much a thrill for a 17-year-old. But just, to be, to be a college student, to be somebody who would just late at night just kind of go around for a ride. Look, some people have commented that that's peculiar. Other people who've said, you know what? Okay, that's his alibi, and that's not all that strange. There's been those different types of comments on social media, but the alibi in and of itself has made for quite a talking point online. Yeah, somebody says, Melissa, in our comment section saying, yeah, look, oh, no, wrong comment. Melissa says, driving is my therapy. Yeah, look, driving can be therapeutic for people. It's a way to clear your head, get a change of scenery. I think that there are people at home shaking their heads like, yeah, you know what? Driving it can be a therapeutic experience. Sometimes with the windows down too, just getting some fresh air and just getting out of your house. So often are we at home and or at work. Sometimes you just need a change of scenery. So people like to go for a drive. I see your comment, Barbara. I'm just reading your comments here, folks. Yes. No one is live streaming this right now. And no, live streaming like outside of the courthouse from your phone doesn't count. We're talking about the pool camera feed from inside the courtroom. Natalie, yeah, I want to know too. Let's see if Alex got back into court. Yes, he is back in court. So let's follow this thread now. Okay, next witness is up. It's Dr. Leah Larkin from California. She's a genetic genealogist and admits that she is nervous. Interesting. Larkin first began researching genetic genealogy back in 2014. Her background in biology helped her pick it up very quickly. She's self-taught, but now teaches courses at the Salt Lake Institute of Genealogy. She says that she was approached by the defense and that her role is to educate on how genetic genealogy works. And Alex is about to step back outside of the courthouse. Being somebody who was formerly a TV reporter, I understand that you got to hit your times. So you're in a rundown. Look, you You absolutely have to hit those marks. Your producers are counting on you. Your network, your channel is counting on you. Here's Alex Larkin said she was approached by the defense. Her role is to educate. Okay. So, and look, I look forward to hearing some of this testimony when we're able to get the pool camera feed upon the conclusion of today's hearing. Quick break. Stand by. Live from the Stream Center. Muting mics. Hold on. And we're back live. Waiting for the conclusion of the hearing so that we can share it with everybody here on stream. Can confirm as well that there is no press feed that is being streamed out. It's strictly prohibited. Excuse me. So there is no signal coming out of the courtroom right now. They are just waiting for the case to conclude, and then we'll tap into that satellite feed to bring it here live on stream. We are going to be taking a break in about 10. We're going to stay on stream, but we're going to be taking a break in approximately 10 minutes to allow for other streaming programming. But we're going to keep the YouTube live open so that the moment that the actual feed becomes available to us, we can have it for you right here on YouTube live. But we do cover a lot of news. We do a lot of weather forecasting. We have sports coverage. We have a lot of streaming programming here at WFLA. So as we await, and we don't know how long this is going to be. We have no idea how long this motions hearing is going to go on for. So we are going to have to take a programming break at some point. But we will not end the stream. But yes, I will have to step away from the microphone for a bit at about 10 after the hour. So in about 10 minutes from now. All right. Any other questions, comments? You can use hashtag KJB to get my attention here in the Stream Center as I hit the touch screen here. If you look on this screen to my left, I see your comments. If you use hashtag KJB, that's how you're signaling to us that interactively you would like to be part of our live stream and you want to comment at me and you want, if you basically use the hashtag, I can tap on it and I can animate your comment on screen and bring you guys into the conversation. So that's why I'm looking so often in this direction. It's because I'm looking here at the screen where all the comments are coming in. So Maui Girl and prayers for Hawaii, by the way. My goodness, just following everything that's been going on there. How long has the hearing been going on? It began pretty much on time, as I understand it, right at the scheduled start time of about roughly 1:30 Eastern, 10:30 Pacific, 1:30 Eastern. That means that they are, as of right now, about 90 minutes in. Now, when I was talking to various people, trying to get an idea as to what the expectation was for how long this is. Hold on, I'm seeing a feed pop up. Oh, okay, that's old video. See, I almost got caught. there is a feed of old video being transmitted, and that is not. Yeah, see, they just cut back to studio. Um, yeah. So for a second, my heart sank. I was like, wait a minute, did I miss something? But no, we haven't missed anything. The hearing is still going on. It's been, to answer the question from Maui Girl, it's been going on for about 90 minutes. And when I did, my homework before today, just trying to get an idea, trying to ascertain as to how long this could go on, what would be expected or standard for a motions hearing like this, I was told 60 to 90 minutes. But it sounds as if they're going to blow past. They already are at 92 minutes now, roughly. You can see the timestamp, by the way, in the bottom right-hand portion of your screen. It's right underneath our sponsor, 1-800-ASK-GARY. You can see it there. It says 3:03 Eastern. So that's how we can also timestamp this. Some people might be watching this on demand afterwards, after we've been live. Of course, if you are watching this video on demand, I very much encourage you to scrub forward, scroll forward, fast forward to the trial, because all of this now, we're just waiting, really, or not the trial, excuse me, the hearing. We're just waiting for the hearing to conclude so that we can share it with you on stream. What are some other questions and comments that we have coming in? Dexter, this is a great question. Do we know how many witnesses that there are today? There's multiple, but I don't have an exact count of how many. But it's a group, several. So I think that we are on to the second, if I'm following along here accurately. And again, this is all about DNA, folks. This is all about the touch DNA evidence. And the 99, what was it? How many nines were there? 99.9999% chance that it was related to, that DNA sample was of the person's father, I believe. So again, we have, we're all, receiving a bit of an education through how DNA is legally obtained. We're going to be, of course, finding out more about how a DNA profile is established, how it is connected between an immediate family member, in this case a parent, to the suspect, him or herself. And so that DNA, what people don't understand as well, I think, or it's not that they don't understand it, but sometimes it gets lost in translation, is that DNA technologies and DNA methodology and some of the tools that forensics departments across the country have, the technologies are changing all the time. It is still a science that is becoming more and more advanced, and this is something that is, DNA has been widely used in countless trials in years past, but the actual technology that is used to establish a DNA profile for a suspect or for an individual is, the technology is still advancing. But exactly understanding exactly how a DNA profile is established and the means for which that DNA was obtained, that is all something that has to be played out legally, or should be played out legally, or can be played out legally, so that that they can establish that there weren't any flaws or any chance that that the technology is flawed, or the means in which the DNA was established or obtained was flawed. So the DNA is going to be a massive part of today's motions hearing. When we are able to play it back live, it will also be a really big part of a trial, as we expect it. Now, Peter was saying, of course, that there's always a chance that that something happens where a piece of DNA evidence gets tossed out. I think it's pretty fair to say that that is considered to be, in all likelihood, a relatively small chance. Everything's relative, but that would be a dramatic change, of course, in the trajectory of this case if DNA evidence were to get thrown out. But the DNA is getting discussed in court right now, and some of the methodology and some of the technologies that were used for law enforcement to use this to find their suspect. Got another 3 minutes here, folks. So let's. Marcy's says, #KJB, do you think the trial will still take place in October? Every attorney I've spoken to about this, Peter and others, just there's a chance, but that would be a surprise to every attorney that I have spoken to. It'd be a total surprise that we would be in a trial in 2 months from now, roughly. That just feels. We've been down this time and time again. Delays are and they're just inevitable. Or at least it can feel inevitable. Delays happen all the time. Trials that can push back not months, but sometimes years. Now, in this case, there is a high level of confidence that the trial would happen within the next roughly 6 months. Most of the attorneys, or I think every attorney that I've spoken to, has expressed that high level of confidence that a trial, if it does get delayed past October, won't be that long. We're not talking about years down the line, but the chances of it actually happening in October are relatively slim. Yeah, Style wants to know, do we know what this hearing is about? Yes, several motions have been put forth. Of course, the subject matter right now is very much about the DNA component to this case. And then also, too, we expect, based on, again, on legal analysts that we've heard on network television, as well as ones that I've had conversations with, there is a expectation that the schedule for the coming months will become more clear upon the conclusion of this hearing. So towards the end of this hearing, we might get a better idea as to how the next few months will look in the Idaho murder trial. Again, suspect Bryan Kohberger, charged with 4 counts first-degree murder. Prosecutors have sought the death penalty, and he's also facing a burglary charge as well. And there's a lot to go through between now and trial, but we're still, of course, awaiting when exactly we are going to have that trial begin, if it is, in fact, going to be in October or beyond that date. Folks, here in the Stream Center, we are taking a break for a little bit. I do not know how long that break will be. I anticipate it not being that much longer than I would say 20 to I would say at the very most 30 minutes. And again, this is an opportunity for us for additional stream programming to be going on at the same time on WFLA.com. So I'm going to be stepping away from the microphone. The live stream will stay up, but with muted microphones. And will, of course, if the court feed, if the court hearing itself ends all of a sudden and we get that feed come in, doesn't matter what other stream, I will make sure that it's transmitted and redistributed to you here on stream. But I am taking a break off the microphone just to allow for other stream programming to fill the gap, so to speak, as we await the conclusion of the hearing in Idaho. But if you have found this live stream and you are looking for the court feed itself as it is being transmitted from Idaho to news stations and media organizations across the country, around the world, as that feed is being sent out, that is the exact feed that we're going to be tapping into. So you will be seeing it at the same time as everybody else. It's the same primary feed that we get here in our newsroom and other newsrooms across the country. So that will be taking place sometime this afternoon. We'll, of course, have that here for you live on WFLA Now. I'm taking a break, and I'll see you in a little bit here after our next stream concludes. Thanks so much for being here with us on WFLA Now.
WFLA Now will begin momentarily. WFLA Now will begin momentarily. Live from the Stream Center in Tampa, Florida. Top stories, breaking news, interactive coverage in the palm of your hand. This is WFLA Now, powered by 1-800-ASK-GARY. Here's JB Buno.
Right now, Bryan Kohberger back in court for a motions hearing that is expected to end with key rulings regarding the future of the Idaho murder trial. We're live, awaiting the courtroom feed here in the Stream Center on WFLA Now as our coverage continues from Idaho. Hello, folks. JB here with you from the Stream Center in Tampa, Florida, awaiting the courtroom feed from Idaho. Again, if you're just joining us, we cannot share the courtroom feed until, of course, the hearing ends. That's just the rules in Idaho. It's the rules that they have with the judicial system there. So at the conclusion of the hearing, we can transmit and live stream a playback of today's motions hearing with these key decisions that are expected regarding genetic genealogy, key decisions potentially on they're going to be discussing the alibi in a courtroom today for the first time. And then additionally, when a trial is going to actually happen. October is on the schedule, but legal experts, pundits, analysts, they have repeatedly stated that the likelihood of this actually beginning in October is quite slim. And so if it's not October, then when? When will we have a trial? Will it be around Thanksgiving, Christmas, or could it actually happen in 2024? There's a lot being decided right now. And we have been following on Twitter some of the reporters that have been tweeting along, live tweeting, because the camera's in there shooting video. Reporters are in there tweeting. The primary restriction that makes this a little bit of a challenge to cover is just that the camera cannot live stream from the courtroom, which of course means that we cannot watch this unfold live, although we can watch it unfold once it's being fed out from Moscow, Idaho. So that's where we find ourselves right now. Hello to Allison, Joan, David, Steve, Chris, and somebody in the YouTube comment section by the name of Rocky Balboa. Those are great movies. Hello, Rocky. Good to have you. Yes, saying hello to all of our commenters. Real quick, just shout out, where's everybody watching from? We're going to go through some of the particulars of the motions. Going to kind of go through what we are expecting today and what is going to be heard and where things stand right now. But let us know in the comment section where exactly you are watching from. Helps us to know where our audience is. Are you watching from in the state of Florida? Are you watching from the state of Idaho? Are you watching from the United States? Are you watching abroad? Let us know in our comment section. And if you use hashtag HeyJB, we will feature some of your comments coming up here. But let's, Alex Caprariello is, of course, our NewsNation correspondent who is covering this, and he's in the courtroom, and he's tweeting along. And Alex, his most recent tweet, I think, was about 15 or so or 20 or so minutes ago. To our understanding, there is a series of defense experts that are testifying right now. The first one by the name of Stephen Mercer, another one by the name of Leah Larkin. And right now they are experts in the field of genetic genealogy, DNA. And of course, DNA considered to be integral to the prosecution's case. It's not the only evidence by any stretch of the imagination. We have, of course, heard about the evidence regarding Bryan Kohberger's mode of transportation, the white Elantra, and we've heard so much about that. We have heard so much about the cell phone pings and him being in that area. There's a lot that the prosecution has, according to prosecutors, according to law enforcement. And speaking of which, there hasn't been much discussed over these last few months, really since the beginning of this year, because of a gag order that was filed in this case that has made it very difficult for certain people connected to this case to be able to speak with the media. The gag order remains mostly in effect, so that also creates a unique obstacle in regards to covering this story as a journalist. The lack of accessibility with certain people connected to this story, some of the people who know this story best, some of the people who we were following routinely, awaiting updates in the murders of Ethan, Xana, Maddie, and Kaylee, who you're seeing pictures here on your screen. We know that there are family members who are paying close attention, family members of the victims who are paying close attention to this today. We also wouldn't be surprised as well if family members of that man right there, Bryan Kohberger, were following some of what's being reported today, or even following live streams such as ours. Reason being, of course, is because this is considered to be a pre-trial hearing that could change the course of this particular trial. And the decisions made on these 6 motions will impact, of course, what this looks like in the months ahead. Let's go over those motions. The defense motions, a request to compel the state to disclose DNA profiles. That's what is in large part being discussed right now, is DNA. A request to stay the court proceedings to investigate potential procedural issues with the grand jury. That will also, that's on the docket for today. Let's see here. The prosecution's motions, the 4 of them, are connected to the alibi that has been put forth by Bryan Kohberger, which we were discussing earlier on stream. His alibi is that he was just driving around November 12th and 13th of 2022. Additionally, protecting the disclosure of information involved with specifically the genetic genealogy component of this case. There's a motion regarding the timeline of the trial, and that will largely, as we understand it, dictate when a trial could begin, and a request as far as deadlines with some of the pretrial activity as well. So just a litany of things that need to get addressed today. What was very interesting is that the pre-hearing notion that this was going to be done in 90 minutes was completely wrong. And I spoke to several different people, and the expectation was that this was going to be done by about 3 o'clock or so Eastern. The time is now 4:09 Eastern. And a feed just popped up here, and I just want to see if that feed is related to at all this story. Stand by 1 second, folks. All right, Mike's back up. So paying close attention to the feeds here because a feed might be getting closer. I'll pass that along. Again, monitoring things here in the Stream Center and ready at the moment. We are given the green light to share that feed with you. Aha. So they have taken a lunch break. And I'm trying to, as I understand it with court policy, I'm not entirely 100% sure. Again, being I'm not presently in Idaho. And also, too, I was explaining to Peter earlier that I have been trying to do my very best to do homework on Idaho court policy and procedure. But I believe that this feed, now that we're in lunch break, might be getting closer. They might feed this back. Very interesting. Stand by. Muting mics again one more time to confirm.
They win.
Good.
Good.
All right. Thank you. Okay, we are on the record. This is State of Idaho versus Bryan C. Kohberger, CR 29222805. Mr. Kohberger is here in the courtroom. He is represented by the team of Ann Taylor, Jay Logston, and Elisa Massa. We also have representing the state, Mr. Thompson, Bill Thompson, Ashley Jennings, Ingrid Beatty, and Jeff Nye. We have several motions set for today. The state's motions are motion for protective order that is related to the investigative genetic genealogy DNA issue, which is related to the Mr. Kohberger's motion to compel, seeking those genetic genealogy information and discovery. We also have a motion to reconsider the order staying time for speedy trial. There's also in opposing that, a second motion to stay proceedings regarding alleged irregularities of the grand jury. And from the state, we also have a motion to compel notice of defense of alibi and a motion for scheduling order. So that's what we're going to hear today. I think we're probably going to use most of the morning with the motion for protective order and the third motion to compel. We expect some testimony from Mr. Kohberger's team. And go first in terms of the argument. Mr. Thompson, go ahead.
No, that's good.
Yeah, I mean, who would first make the argument on the protection order? Would you prefer to do that after you hear the argument from the defense?
It may make more sense, Judge, to do that. I think the record will be better for Your Honor.
Okay, that's why I suggested that. Thank you.
Yes, sir.
All right, so we'll hear the testimony and argument from Mr. Kohberger's team, and then to the state.
Your Honor, just for the record, Mr. Nye and Ms. Beatty are the ones handling this particular motion. Ms. Beatty has the witnesses, the proposed witnesses, Mr. Kohberger and Mr. Nye, of course, briefed the matter and will be prepared for the argument.
Okay, excellent. Thank you. All right, call your first witness.
Your Honor, along those lines, I can inform the court that I'll be handling all of the witnesses that we call today. Ms. Nassau will be presenting our argument in support of our motion to compel, and probably the rebuttal to it practices or request by the state.
Okay, you all might need to remind me as we go along here.
Sounds fair enough to me.
Okay, Ms. Beatty.
Your Honor, as a housekeeping matter, I have some objections that I'd like to put on the record
Okay.
with regard to these witnesses. With regard to Ms. Barlow and Mr. Mercer, the state made its concerns on these two witnesses clear in its reply brief filed on July 14th. But the state believes that calling two attorneys to testify about legal conclusions during a discovery dispute is simply not proper. Both Mr. Mercer and Ms. Barlow consult with defense attorneys on discovery issues, and calling them to testify about legal conclusions in a discovery dispute is tantamount to the state calling prosecutors as fact witnesses to testify about trainings that they've done in a specialized particular area. That's a path I don't think we want to go down, and it's not relevant to the court, and it doesn't fall within 702, which requires specialized knowledge for the fact finder, which is the court in this case. Additionally, Ms. Taylor is an attorney practicing in Idaho who's well regarded and seen as one of the preeminent defense attorneys in the state. There's nothing that these witnesses can call the court that Ms. Taylor can't simply consult with them about and argue to the court. So our position is that these witnesses' testimony is duplicative of whatever Ms. Taylor can argue, and it does not fall within the scope of 702. With regard to Gabriela Vargas, the state is objecting to her testimony as well, Your Honor. We received her declaration just yesterday. There was no CV attached. Ms. Vargas is being submitted to this court as an expert witness, and the state has no way of vetting her expertise without a CV. There is no way for us to verify anything in her affidavit. It puts the state in essentially an ambush position where we're being presented with this witness with no way to verify her qualifications. We would ask that this witness be excluded from testifying today as well. And then finally, the state would just make a blanket motion in limine that these witnesses not be allowed to testify about legal decisions or legal arguments. Thank you, Your Honor.
Ms. Taylor?
Yes, thank you, Your Honor. Your Honor, the first two witnesses that the state objects to, Victor Barlow and Steve Mercer, are two people who have been known to the state for quite some time. What they say to you in court now is their objection was made known on July 14th in their reply to, in support of their protective order after we did a response to their motion for protective order and an objection to it, that it's not an objection to them testifying. They spent a lot of pages telling the court why the court should not pay any attention to the declarations that were attached to our third motion to compel. So that's not an objection to them testifying at all. These witnesses have been made known for a long time. They were certainly known last week when we had a planning session and we talked about the number of witnesses that were going to testify. No objection was stated at that time either. Waiting until today, when those witnesses have both traveled and been here and been prepared to testify, that's an ambush, Your Honor. They're here, they're prepared. Their testimonies are relevant to the issues that the court has to decide. They're going to talk to the court about two different things as it relates to our discovery rule and the information that Mr. Kohberger is seeking so that we can do our job. Your Honor, you're going to hear from a witness, Leah Larkin, Dr. Leah Larkin as well, and she's going to talk about the process of genetic genealogy. Both Ms. Barlow and Mr. Mercer are attorneys. Both are well-versed in criminal defense. Both are well-versed in DNA and genetic genealogy. The state's position has been that this is not discoverable because we're not going to present it at trial. That's not the end of the story. That's not the discovery rule. And those are the things that Victor Barlow and Steve Mercer will talk about. Victor Barlow has a lot of training in DNA. She does a lot of teaching on DNA as well. It's not a simple little process, and they'll describe what kinds of materials we should have in discovery. Mr. Mercer will talk about what we will do with those kinds of materials and why they're necessary to Mr. Kohberger's presentation or preparation of this case. They'll talk about our constitutional duties to Mr. Kohberger. Those are not conclusions. Those are things that have to do with this material, these things that we're seeking the court to order the state to turn over to us, and why they're necessary to the preparation of the case. So for those two witnesses, I can make the argument, but I don't have the expertise in the DNA or the genetic genealogy that the court needs to hear to understand that they fall squarely within our discovery rule. Your Honor, I'll speak about Gabriella Vargas now. Her declaration was disclosed yesterday. Much of that declaration has CD-related items in it. It talks about her background, her training, right in the body of that declaration. That declaration is not as soon as we would have wanted that. Gabriella Vargas met with me a few weeks ago, and for personal reasons that I'm not going to put on the record, she was unable to complete that until a later period of time. So that one is, like, I know that one came in yesterday. She's here, she's prepared to be cross-examined by the state, and certainly there are many other remedies besides just excluding her. The court could allow us to present her testimony, and the state doesn't feel that they've had opportunity to cross-examine her or present a witness in response to her. The court could leave this open and take that up. The court could even order Ms. Vargas to appear by Zoom for further cross-examination. But we should at least let her testimony come out here in court today. She's here.
Your Honor, I think Ms. Taylor has just conceded that these attorney witnesses are going to be testifying about the scope of discovery rules. I don't think that that's appropriate. I think that Ms. Taylor can make those arguments to the court that having fact witnesses interpret the law is not appropriate in a discovery dispute. As to Ms. Vargas, our understanding was that there were 3 witnesses testifying today, and that was our understanding up until yesterday when we got into town. So we would ask that Ms. Vargas be excluded. And I would note that we made our objections to these witnesses clear when we asked the court to disregard the contents of their declarations in Mr. Nye's reply brief. Certainly, we're going to put that same objection on the record. Thank you, Your Honor.
Well, a couple of things. I'm concerned about these opinions about sort of constitutional law or the procedures of discovery. I think that's fully capable for all of the counsel here. Those are going to be my decisions. However, in reading through, and I have read through all of the declarations, pointing on specifically genetic genealogy and their experience with that within the law, I think does have some relevance potentially. And I think that it would go to the weight of the consideration. The other thing that I am concerned about is this is a death penalty case. And if I deny particular presentations that one or the other side believes have some bearing on the case, it's probably more wise for me to allow it, even if it might be on the edge, than not allow that record. It's especially important in a case like this to have a record for appeal. So I'm not saying one way or the other how this might fall, but I think it's important to preserve the record. Now, however, I don't want to get into arguments about the law or what that exactly means. I think I have a pretty good understanding of what the issues are about the genetic genealogy issues and why the state wants to get more information about that. I also understand why the state believes that it has nothing to do with the case. And that's what I'm going to hear from today. And it's important to have both sides weighing in on this. Now, with regard to Ms. Vargas, she is here. I don't know where she came from, how far away. I'm inclined to just allow the state to come back and address that. Also, file a brief objection. So that's where I landed on all of that. So I'm going to deny the objections. Testimony. Now, if you get too far into this is what the law requires, okay?
Thank you.
So I'll call your first witness.
Your Honor, if I may, one point of clarification. It occurred to me while listening to the court talking about genetic genealogy and really that being the focus. There are a couple of other areas contained in the motion to compel that have to do with the other DNA that state doesn't have the discovery to us that are included in that third motion that we called about for today. The big focus is then the genetic genealogy piece, but I wanted to make sure that that was still in the scope of the court.
Well, my understanding was that the state did provide all the information about the laboratory, let's say the laboratory DNA that was, that analysis was not related to the genealogy DNA. Am I mistaken about that? What are you
had a section called Standard Lab Discovery, and that has to do with other DNA profiles found at the scene. They have provided full discovery for the sheet, the DNA found on the knife sheet, but not the other 3 unidentified male DNA samples, 2 from within the house, 1 from outside of it.
All right, so if I'm understanding your question there, or your assertion that we're talking about 3 potential analysis of DNA that was not provided to you, but that has no connection to Mr. Kohberger.
Correct.
Okay, any response?
Your Honor, we didn't realize this was going to be an issue today. We have given
I
the
didn't either.
defense everything that we received from the lab. They've asked for DNA workups on other people. To the extent that they don't have them, they weren't done. We can't produce something that doesn't exist. We have provided everything. There's one outstanding lab report that relates to the forensic examination by the lab personnel of the crime scene itself. Will be received today. That's the only outstanding lab report. Everything else, along with all the notes, is what there is, and it's been provided to the defense. And if they're hoping that there's something else there. It's not there.
Taylor?
Well, Your Honor, it's part of our third motion to compel. It's still something that we don't have. We also don't have the unexpected corrective actions, unexpected results from the Idaho State Police Forensics Lab for the 6 months before and the 6 months after November 13th, 2022. We did get some, but it's a narrow scope, and we asked for the full year, 6 months before and 6 months after. That's also in our motion to compel, and we don't have that.
I understand your responsibility is to turn over every rock. But you can't get things that as well. So, I mean, there has to be some level of trust in discovery. You're all sworn attorneys. So, Mr. Thompson is saying that there's one more lab report that is going to come your way today, I heard her say.
Maybe not today. We were waiting to receive it so that we can process it for discovery. It's supposed to be in any time.
Okay, I misunderstood. So it's coming soon. It has to come soon because we're 6 weeks away from the trial. So we're going to be very rushed about a lot of things. But we will talk about that. So what about the other claim, Mr. Thompson? Do you want to address that? The other mistakes?
Corrective action log, or unexpected results log. We have that in part, but not the full scope.
I don't know what exists that we haven't received. We've provided all the requests to the lab, and they've assured us that they have provided us with everything that they have within the scope of those requests. I'm not sure what else to say. I mean, we can make a supplemental inquiry to clarify that after we finish in court today. But I'm kind of sitting here saying, Judge, we've given you everything we know to exist.
Well, that would be wise to check on that.
We will.
Because we don't want this to come back on the eve of trial.
Yes, sir.
Or, 4 years from now, they appeal.
Yes, sir.
So we want to make sure that we have combed through all the information that has any bearing or argument of bearing on this case.
Ms. James is making a note right now. We'll send the inquiry out later today.
Okay.
Thank you, sir.
Your Honor, just for a point of clarification, we also ask for all emails, text messages, electronic messages, or other messages. Some have been provided, but we don't have assurance that that's all. And so for the same reason, we want to make sure that we have the complete file.
Okay, Mr. Thompson.
We have told them, we have given them everything that we know to exist. We've asked the lab provided it to us, we sent it to them. At this point, all I'm hearing is speculation, is they think maybe or they wish something else was there. But as far as we know, it doesn't exist. I don't know what else we can say. You can't respond to something that isn't real. Sorry, Judge.
We're just sorting it out.
Yes, sir.
Making sure that everything that there is shared. Except for the ones that you don't want to have
Absolutely.
shared.
Yes, sir.
And that's one of the reasons we're here.
We'll make an additional inquiry to the lab to see if there's anything else in the form of emails that they haven't already provided to us.
I would add, I mean, there are times, okay, in the world of law, that sometimes people forget to do things, or sometimes things fall through the cracks, and so it's always healthy to make sure that it is done thoroughly.
Absolutely. Thank you, Judge.
Your Honor, we're ready to call Steve Mercer.
Okay. Just going on, are your experts in the courtroom right now?
Yes.
Do they need to be in the courtroom?
Your Honor, I'd ask that they be allowed to remain in the courtroom, seated where they are, so they're just kind of alone right now.
Right. Any objection to that? I don't know who is here.
Your Honor, we ask that the witnesses be excluded.
I'm going to exclude your witnesses, so they're not hearing what the other witnesses are testifying by, and that'll be, I think, a clear accurate response. So then I don't want to have them reacting to the other testimony or hear each testimony or each witness's testimony be independent. Okay, so if you please have your other experts.
Your Honor, where would the court like them to go? This is a media-intensive environment, and I don't want them to be bothered by the media while they're waiting to go.
The law library.
May I slip in there?
Sure.
Right.
Second, Mercer.
Thank you, Your Honor.
Okay. Thank you, Taylor. Okay, Mr. Mercer, hang on up. Please raise your right hand. Hey, yeah, please.
Do you solemnly swear that the testimony you give in this case shall be the truth, the whole truth, and nothing but the truth under the penalty of perjury?
Thank you. Mr. Mercer. Go ahead. Get some water there. I'll take care of that. And once you're seated, will you please state your name and spell your last.
Yes, my name is Stephen with P.H. Mercer, M-E-R-C-E-R.
All right. Thank you, sir. Okay, Ms. Taylor.
Good morning, Mr. Mercer.
Good morning,
What city and state are you from?
Rockville, Maryland.
What do you do for work?
I am a licensed attorney in Maryland and the District of Columbia in the field of criminal defense with area of specialization in DNA and forensic litigation.
How long have you been an attorney?
I was licensed in the state of Maryland in 1995 and in the District of Columbia in 1997. I'm also the member of several federal bars, including the Supreme Court, where I appeared as co-counsel in Maryland v. King, a DNA database case from 2013, as well as the Fourth Circuit, the D.C. Circuit, and a number of federal district courts.
I want to back up a little bit and have you tell me about your educational background.
So I have an undergraduate degree, bachelor's degree in English from Syracuse University, 1984. Juris Doctor JD from the District of Columbia School of Law from 1994.
And you mentioned you have a specialty in DNA. Where does that come from?
So my experience with DNA began with the first constitutional challenge to Maryland's DNA database statute, and that started in 2002 in the case of State v. Raines, where I raised a Fourth Amendment challenge to the compelled collection of DNA from convicted offenders. Prevailed on that case in the trial court. It was appealed to the Court of Appeals, which is now called the Maryland Supreme Court. The Maryland Supreme Court, in a sharply divided 4-3 decision, reversed, sent it back for trial, tried the case, and that was really the beginning of my experience with forensic DNA litigation. And then from that point, I continued in that field, attended training with the District of Columbia Public Defender Service. I began to collaborate with the Innocence Project and the Forensics Division at the Maryland Office of the Public Defender, doing indigent defense work and innocence work, and began to work closely with DNA scientists, who actually did the wet chemistry work, had numerous opportunities to tour law enforcement labs, including the NIST lab, as well as Montgomery County's lab, Bodie Technology, the FBI lab.
Involved in this?
Yeah, so the question was, what would a reasonable defense attorney do when confronted with DNA evidence that needs to be litigated? What are the minimum practice standards? So I'm not here to discuss Idaho's discovery rules or offer legal opinions about constitutional standards. Rather, my area of focus is based on my experience, training, and expertise in forensic DNA litigation, and what a minimum practice standard would be for a reasonably competent trial attorney who must comply with their duty to investigate the case on behalf of their client.
And is that because of what you get when you get genetic genealogy materials?
Well, yes. I mean, forensic evidence is often central in the case, and DNA evidence in particular. And so when there's an item, for example, here of an environmental sample of trace DNA evidence that, as I understand it from reviewing the pleadings, was twice tested, first for an STR profile, and then later for a genomic profile. The question becomes, what is the minimum practice standard for an attorney to be effective in their representation of a client given that type of evidence?
When you're talking about two samples happening or two tests happening, why should an attorney know about that?
Well, there are a number of reasons why it's crucial for the attorney to investigate any testing of evidence that is central to a case. And again, here it's an environmental sample of trace DNA that is being tested. And so it's essential for the attorney to know, for a number of reasons, about the details of the testing and the investigation when we're talking specifically about forensic genealogy. Number one is there's pretrial concerns, and those pretrial concerns that can be raised would involve suppression issues and potentially Fourth Amendment issues. These are questions that are very much evolving in the state of our litigation. But to understand viability of a Fourth Amendment challenge, there has to be a factual investigation. There has to be a determination of the conduct that law enforcement undertook during the forensic analysis of the genealogy. So, for example, was it fast and loose? Was there searching of databanks that violated the terms and conditions of those databanks? Was there surreptitious DNA collection from targeted individuals in family trees? So these are very fact-specific inquiries that the attorney must know in formulating a suppression challenge under the Fourth Amendment, because it's all about reasonable expectations of privacy. And what's really critical here to understand, and this is close to me from my litigation, early on, the government and law enforcement's argument was always there are minimal privacy interests at stake because forensic DNA profile is like a fingerprint, and it says nothing about who the person is. But now with forensic genealogy, we're talking about genomic profiles, potentially whole genomic profiles, or at the very least a SNP profile, single nucleotide polymorphism profile. Single nucleotide polymorphism. An SNP profile that contains a vast amount of information that is very, very private. And so this is a real game changer in the privacy interests that are at stake, and that the attorney needs to understand in investigating the case to assess and to evaluate that suppression issue, that Fourth Amendment issue. So that's one issue pre-trial. There's also concerns about reliability. And by reliability, I'm not talking necessarily about the forensic genomic profile, but I'm talking about the STR profile. And again, because as I understand it from the pleadings, there were multiple tests on the same environmental sample of trace DNA. One produced a STR profile that I understand from the pleadings is represented as being a single-source male profile. The reliability of that needs to be investigated, and certainly through one aspect of that is investigating the laboratory documentation that is provided for the STR testing. But we also have to appreciate, and again, I'm not a DNA scientist or a biologist, but I'm an attorney that works with experts, and I need to know what type of expert to hire. And one thing that I do realize in looking at this is when there's multiple tests of the same piece of evidence, and you have a genomic profile, in other words, potentially the entire human genome that is typed from this environmental sample of trace DNA, or at least an SNP profile, which is somewhere in the neighborhood of 700,000 locations of data. What does that tell us about the STR profile markers? So for example, the STR profile markers, which are typed, are 20 out of 30,000 STR markers overall. And so what I would be investigating with a qualified expert is, number one, and I don't know from the pleadings if there's a whole genome profile that's been developed for the forensic genealogy, but if there is, that should contain STR markers. What does that tell us about the reliability of the STR testing? Is there any potential for artifacts? Is there any potential for an undetected low-level mixture? Those types of questions that are potentially available to inquire and ask about where you have multiple tests of the same piece of evidence, and it's an environmental sample of trace DNA. Now, if it's just an SNP profile, I say just, but that's 700,000 locations of information that is like a probabilistic future diary of someone's health, medical, and all manner of conditions that are linked to genetics. That may not have the STR markers in it itself, but it will have information SMP markers in the neighborhood of, so to speak, of STR markers that will also shed light potentially on those STR markers and the reliability of those STR markers. So these are, particularly in a capital case, crucial areas of inquiry that must be undertaken by the defense team in conjunction with experts that they retain. But they can't even decide what
The feed from Idaho has cut out. They are currently in black. This is the feed that is coming from Idaho. So that means that what is being fed from the courtroom right now is a period of black. So some kind of a technical difficulty from Idaho. There you can see that is the logo for, of course, the transmission company that they're using to feed this out to various news stations across the country. JB here with you folks in the Stream Center, monitoring this, of course, listening in, paying close attention, taking notes. And that was I'm sorry, I want to be clear. I don't know if it was Dr. or Mr., but it's Stephen Mercer, who is a expert in genetic genealogy. He's speaking here today. And he has been called by the defense, of course, by the team of Bryan Kohberger. Exactly what went wrong with this feed. I'm looking here. Our coordinates are correct. The means in which we received this feed, everything is good on our end. So clearly, a problem has occurred on the pool camera feed end from Idaho. We hope to have that fixed at any moment. It could pop up really at any moment. And we don't know if it's going to pick back up where things cut out or if there's going to be a gap in this particular piece of testimony. You would hope, of course, that it just picks back up where we left off. But I've been commenting here on YouTube Live with you guys, talking a little bit about the very poor audio quality. There are moments where it is difficult because of the acoustics in the room, but let me be clear, you can't see just how many people are in this courtroom and how tightly packed it is. So when we heard some rubbing along the microphone, we heard some crackling as well. That's just because there's a lot of people all close to one another. In fact, I don't know if anyone else heard this. You can give me a thumbs up emoji if you did hear this. There was even some whispering in the back of the courtroom that was picked up because the only source of audio is in the back of the courtroom, and all of the sound is coming from the front, and sometimes if it's coming from one of the attorneys, it's going in the opposite direction. So that's, of course, a problem with acoustics. So you just, if you're picking up on whispers, you just hope that the people doing the whispering are aware that it can be heard, especially when we boost our audio so that you at home can hear it. So that's where things stand right now. After Stephen Mercer is a Leah Larkin or Lee Larkin, one of the two. And exactly when we get this feedback is unclear. In the meantime, let's come back out to the Stream Center and hope, of course, that we get the feedback. In addition to the feed being sent out to various stations across the country, there is also going to be video files that are sent along as well. So the entirety of today's testimony might start to circulate on the internet at some point. I'm just being transparent with you guys as far as how this works. So it gets fed out from Idaho, but then also basically they'll just take the big video file and send it to stations, and sometimes that will appear on the internet as well, like in its entirety. And in that case, you can take your mouse and just scrub to the portions that you want to hear. Right now, they are in break, a lunch recess in Idaho, and we're told that it's about 4 or so minutes away from the scheduled continuation time. They are going to be resuming at 2 o'clock Pacific. That is 5 o'clock our time here, Eastern. And so let me also pass along, in case we get the feedback, I do not believe we are going to be able to, and I have to confirm with our team, but I do not believe that we are going to be able to stream the entirety of today's proceedings in Idaho. Because once things resume in Idaho, that will be 5 o'clock our time, 2 o'clock their time. We have to assume that they're going to go for another 3 hours beyond that. And that means that at 8 o'clock is when would be in that scenario, the very earliest that we could start our live stream with that feed. And so we will not have the staff necessary to do, and we're not expecting an entire day worth of footage to be able to share with you all today. So in reality, what will happen is we were anticipating that there was going to be an hour to 90 minutes of video to share and stream with you today, and then to break that down. But because this is really an entire day, if you will, in court, and the court restrictions in Idaho where we can't live stream it as it's happening, that makes our jobs very difficult. And for those reasons, we will not be able to have the entirety of today's proceedings. We hope to get if you will, part one, the morning session, the session before the lunch break. We hope to get that back at some point here. However, it seems like they've been having some technical difficulties. Not to mention that, look, got to call balls and strikes here. The audio is lousy. It's just terrible audio. And it's hard to hear certain things, especially when it's coming from Bill Thompson, or if it's the attorneys on either side. It's just you can't hear it all that great, and that's frustrating to cover. But also, as some people have been noting in our comment section, at the same time, people are saying, we're just lucky to have this. I like that particular viewpoint, glass half full type approach. We're just lucky to have it. Is it the best audio? No. Would I have loved for there to have been more mics placed around the courtroom? Sure. But the pool camera team doing the best that they can, and who knows, maybe this will lead to conversations about when this actually does go to trial, and how the pool camera team, maybe can upgrade their setup a bit. Choosing my words carefully. Back here on stream. This is now video. So my notes, they just, I think the big thing that I circled in my notes is just, we talked about it earlier, about how genetic genealogy isn't perfect. It's not a perfect means of, if it was perfect, things would be, there are DNA technologies at play here that are clearly evolving. And DNA science is coming a very long way, and new things are being learned all the time. We've had on WFLA, in just the last year, we have had some cold case breakthroughs dating back decades, multiple, because of advancements in DNA technology, specifically in the last 18 months. And that just goes to show that, again, the DNA technologies continue to get better and better. But the means in which DNA is obtained and the means in which someone is identified through DNA, of course, you want there to be a checks and balances system where you make sure that it's being done correctly. You don't want, I'm not talking about Bryan Kohberger. I'm talking about just in general. I'm talking about you do not want somebody being falsely accused of a crime because of a DNA deficiency. So there has to be a checks and balances system, because a lot of this conversation in this testimony that we just heard from, a lot of it, look, going over our heads. A lot of what you hear about genetic genealogy, sometimes you even heard some clarifications requested because some of the jargon, some of the scientific terms that are used, just the average person in court, the average juror, isn't going to be able to fully grasp exactly what those terms mean. So there's a lot here that has to get fully understood. And also, too, part of that has to be an efficient checks and balances system where people, especially jurors, are assured that the process was done correctly to lead us from the DNA that was obtained to the conclusion that was reached with that suspect being identified. There's got to be that A to B or A to Z, and if and that might and very likely will play out in court. Just asking the tough questions about how DNA technology is used to find a suspect, and well, of course, this is why I enjoy my job when it comes to stories like these, because we'll learn. We will learn. Hopefully, the technical terms and the jargon won't be so scientific that we have no idea what they're talking about. But hopefully, we're able to learn enough and follow along. And reporters like myself will do our very best to break things down and help people understand. That's why we have experts that come on stream. But also at the same time, I'm not going to be a reporter who's going to sit up here and pretend that I know every single solitary word of what Stephen Mercer is talking about, because a lot of it is extreme. This is a very complex and vast field of science, of biology. It's extremely nuanced. And so there's a lot to understand, and we're going to do our very best to follow along. Yes, to Dina in our comment section, one of our great moderators. I love it when we all come together and learn new things. Yes, that's part of what we do here at WFLA with live streaming. We learn together. I learned so much during the Titan submersible coverage, didn't you? When we were on live stream that week about deep sea exploration, I was so humbled. And I ended up doing more research about just how much fiber exists in our oceans to transmit the internet, maybe even this live stream, around the world. It's mind-blowing how much internet goes through our oceans. People just automatically assume that our signal just gets beamed up to a satellite and shared continent to continent globally around the world. No, a lot of our signals over the internet, if you're watching from Europe, South Africa, Asia, Australia, a lot of that is going through our oceans because of just the vast amount of internet wiring that exists through our oceans globally. And we learned that I did not know that. Or I didn't know, I knew that the internet went through, of course, our oceans, but just how much of it is transmitted underwater is just utterly, it was made clear on our live stream. Shout out to Mark Martin. Yeah, we learn a lot together on stream, and this might be a story. One of the things that we might really learn about is genetic genealogy and how touch DNA evidence is obtained, how it is utilized, how the experts in their field go from basically DNA code to a person. How we get from that point to that point might become something that we understand better at the conclusion of covering this story. Yeah, still no feed, which is a bummer. Complete and total bummer. Let's move some things around. Let's mess with satellite signals. What is this signal? What is this signal? This, I'm telling you, I'm getting from satellite, not from the ocean. Although, could it be passing through the ocean in some respect? Probably not, because this is a domestic signal, but goes to show just how video and how things get transmitted. I don't think no, it's not on our end. We're calibrated correctly. Well, folks, without a feed and the fact that this is going on for considerably longer, there might be a conclusion to our stream in the not too distant future. I'm hoping that we can get through part 1 today. That would be ideal. Now, I'll just say it again. This wouldn't be a problem if we could just live stream from court. But again, jurisdictional policy. It's Idaho rules. Idaho judicial policy that we can't stream from the courthouse. Yet, if this happened elsewhere in our country, same country, the United States of America, but in a different state, we'd be able to live stream it. It seems very peculiar to me. Again, very much an unapologetic advocate for transparency. And not saying that every trial or every hearing on the planet should be live streamable. I understand, and I've done enough research to know that there are certain scenarios where you do not want a court feed being live streamed or even cameras allowed in there at all. But sometimes I struggle to find the plausible rationale for why it can be shared in one format, but can't be live streamed or televised live. But you know what? That's just the how the cookie crumbles. To quote a great news movie. Who knows the movie? Shout out the movie in our comment section. It's how the cookie crumbles. This is what you get when we lose feeds. See, in the Stream Center, without a stream, without a feed, you get just me, and that leads to movie references. Yes, Alyssa and Save Dat. Bruce Almighty. Which is a movie about the news. And, yeah, classic. Quotable all day long. Sometimes I wish I could just grab a satellite dish and give it an elbow. You know, kind of like when a vending, you have like that vending machine and the potato chips get stuck or the candy bar gets stuck and you just give it like an elbow and then poof, it works. Sometimes I want to go to wherever this feed is coming from, just kind of kick the satellite a little bit and then just poof, it just works. Let's just go back to the poll results and just close this poll. We asked you, do you casually go for drives just to enjoy driving? And 46% said yes, 54% said no. We'll end that poll. 9,000 or so votes. Yeah, I think now I get a better understanding as to, there were some people in our comment section saying, yeah, well, sometimes with kids, a quiet drive, just me and my tunes. That's a funny comment given my situation at the moment. I'm going to give this another 5 minutes. If we do not get a feed, we don't have a purpose for our stream here today. And look, full disclosure, this didn't go according to plan today, but that's live streaming. That's how it works. Sometimes our streams, rarely do streams go according to plan. That's one of the reasons why this room is so, why I have so many screens and why this room was built, was because there's a lot of unpredictable things that happen in the world of live streaming or news streaming. Feeds pop up, feeds go away, breaking news happens. I could look at my feeds right here, and within a moment I see a massive structure fire, a car chase, a significant press conference, other forms of breaking news, and then all of a sudden, just like that, we pivot. I hit the touchscreen, we go to that feed, and we discuss what we're looking at. Today's stream did not go according to plan because it went way longer than what many legal analysts expected. It was supposed to be wrapped up within 90 minutes. It did not go 90 minutes. And I think that was because the amount of witnesses that were testifying to specifically to genetic genealogy, that was a larger group than anticipated, I believe. I don't remember seeing a long roster of witnesses, experts that were going to be testifying today. I might have missed it. I'm a human. I make mistakes. But I was doing research and getting ready for this live stream today, and I did not see a long list of expert testimony. I did know we had 6 motions to get through. In total, of course, they read them out aloud in the court. That became abundantly clear. But all of the witnesses being called, the experts being called to the stand, that I think was part of the reason why this was very much an extended day in court. Let's check in with Alex, NewsNation correspondent. Has he tweeted? Yep, 11 minutes ago, afternoon hearing, court back in session. Testimony continuing. Yeah, guys. All right. Look, things could pick up very quickly, but the pace of this so far, I think it has to be stated. There's a chance that this goes beyond end of business, the end of the business day, which would be 5 o'clock Pacific time, 8 o'clock our time. And it would be up to the judge how late that they would want to go. And if this marathon of motions hearings went on for long enough, would Judge decide, all right, that was enough for today, reconvene on Monday? Look, it's very likely that this is the first motion that they are really digging into. And we saw this. What was the one earlier this year? It was very similar with the Petito, laundry case. There was one motion that it was in regards to the letter, Roberta Laundrie's letter, that went on forever, and then there was subsequent other motions that they got through in 5 minutes. It could be that today. It could be just a very lengthy back and forth regarding genetic genealogy, and then the other motions are done within minutes, just brief conversations, and the judge issues a ruling. I'm clearly just presenting context and presenting potential scenarios. I don't have any knowledge as to, but I'm just providing you with an idea as to some other scenarios at play here. But yeah, who knows how long this is going to go on? It could go on all evening, all night, into next week. It could be wrapped up in an hour. And still no feed from Idaho. So something went wrong. Just reading your comments. The Leela Dog. Hey, Leela Dog. Have they decided if cameras are going to be allowed at the trial? It's expected that the entirety of the legal, basically the trial, everything is going to follow the same judicial policy, which would be that cameras are allowed in there, just can't stream from them, which is a quirk that we've noted here repeatedly on stream. And that's a quirk that's relatively unique, and it's a quirk with Idaho. There are other jurisdictions that have done that, but it's they allow cameras in, but they say no live streaming, live feed. You can't do anything with it until court is in recess or court is done for the day. So we don't expect a live streamed trial in Idaho with suspect Bryan Kohberger. Nick, hashtag KJB, why not talk about the hurricane hitting California? Yeah, we have a show. I'll show everybody here. Hold on. We have a show called Tracking the Tropics. It's one of the other digital shows that we do here at WFLA. And the storm has historic implications, as it would be an extremely rare event for the West Coast to get a hurricane. We've been talking on Tracking the Tropics all season long, Nick, about how unique of a hurricane season this is, with El Nino and alarmingly warm sea surface temperatures across the Atlantic, across the tropics, and how that makes for an not unprecedented, just a very complex set of circumstances for tropical development. So this hurricane season, the next really, and the peak of hurricane season is about 3.5 weeks away. Hurricane season, which is obviously big for us here in the state of Florida, is as unpredictable as ever. This one presents unique challenges for forecasters to be able to get an idea as to how many hurricanes are going to hit and how severe or how major or how significant they are going to be. Cat 1s, Cat 3s, Cat 5s. It's hard for forecasters to get an idea, a grasp on it. We're dealing with extremely warm temperatures here in the tropics, here in our section of the world. Even just here in Florida, the waters here in the Gulf and around South Florida, it's wild. You get in the water here, you get in the ocean, and it's literally, it feels like a hot tub. It's pretty wild, and that's just because we've had just this weather pattern. What our meteorologists have described as a heat dome effect that has just kind of put all of this heat directly on top of us. And so yeah, that has made for a very unpredictable and difficult to follow hurricane season, and that's why that storm in California, my goodness, it's throwing everybody for a loop. We're not used to talking about hurricanes in California in August. That is weird. It goes to show that we're talking about a very bizarre set of ingredients for tropical development right now in our section of the planet. Yeah, weird. So that's Tracking the Tropics. Streams Wednesdays, 12:30 Eastern, 11:30 Central, here from the Stream Center with our very talented Max Defender 8 weather team. But this program is Tracking the Tropics. So we're back here talking Idaho. And we're about to wrap, to tell you the truth, you guys. Any final questions? This is a last call for questions because we don't have a feed to share, unfortunately. Things went down. I got to talk to our team as to what happened in Idaho, where the feed was severed. I'm very confident based on all the data I have in front of me that it was not on Tampa's end, that it was on, it was from them, but, or there's a middleman, if you will, that could have been responsible, but it's not on us. Any final questions? If you use hashtag KJB, I'll shout out some comments. Oh yeah. Great one. From Bruce Almighty. Patty is quoting Bruce Almighty. Smite me, almighty smiter. Yeah, it's just, that is quintessential Jim Carrey. Morgan Freeman is in that movie, Bruce Almighty. And there's just so many humorous parts of that movie. And also too, it's like similar to Anchorman. Being in the news industry and watching that movie, it's funny in a very unique way. Yeah, there's a lot that you can relate to. This is all questions, any and all questions on the table before we wrap up our live stream. Team Brittany, one of our great moderators, saying pools as well. Yeah, too hot to swim on some days. Yeah, it is hot right now in Florida and hot in a lot of different other sections of the country. But man, the Sunshine State is living up to its name. We are feeling it. Manda Panda, could someone try to convince the judge in Idaho to stream the trial on a delay? Well, I'll tell you what, Manda Panda. If you are a tax-paying American citizen, and maybe by just pure coincidence you're joining us from the lovely state of Idaho, and you know Judge, maybe you could pass along a note and say, can you live stream the trial? Because I would really appreciate it. Look, the gag order, the current policy, there's just a lot of reasons to be skeptical that there will be any opportunity to convince anyone in Idaho that this trial should be live streamed. Crazier things have happened. And motions could be filed and things could change, but Cool Dude Bob wants to know who's winning the NFL preseason game tonight. It's not the Bucs because the Buccaneers are Saturday. So who is it tonight? Tonight it's preseason. It's mostly roster invitees fighting for their spot on the roster. It's not about winning or losing. It's about getting in reps. It's Carolina against the Panthers against the Giants and the Bengals against the Falcons. Just because, give me the Giants and the Bengals. We're going to go against the two NFC South teams. So there you go. Just know that is just me picking names out of a hat. Giants, Bengals. Okay, what else? Final questions before we wrap up. Yadira Flores, could you do a petition to have them live stream the trial to change court policy? This is why lawmakers exist. This is a random petition from people who want to snack on their popcorn and watch this trial unfold. No, I mean, in all likelihood, I'm just telling you from experience covering stories, and to get policy change, you need a policy maker, and so it's usually through not necessarily. Could you take a petition to a lawmaker in Idaho? Sure, you absolutely could, but first you need the signatures, and then you need the audience with that lawmaker, and even then they might say, this isn't a priority, or this isn't something, or they listen. I'm just, a petition would only really likely work in the event that it was taken to a policymaker to change court policy, because this is very much a judicial policy that has to be altered for a feed to be distributed from the courtroom. Faux Fauna wants to know, what are your thoughts about the reasoning for no live stream? It's court policy. As I understand it, it is court policy. It's judicial policy for this particular jurisdiction in Idaho. But there's nothing wrong with asking just why that policy is the way that it is. What is if the judge gave us a reason, we could say, okay, that's the reason. Okay, that's it's your courtroom, judge. But it would be just nice to know why you don't permit live streaming. But you permit a delayed feed once you go to lunch. That's kind of weird. One or two more. Gail, I'm sorry. Maybe next time you catch us. Nathan, just because I love this question, I will admit that I am a very passionate USMNT fan, and so I root for the soccer teams that have American soccer players. So Christian Pulisic, Gio Reyna, Matt Turner, Weston McKennie, Tyler Adams. I am a big U.S. soccer fan. So if that's who I root for. It's just the truth. But I know that we got a lot of folks joining us from the UK that are probably rolling their eyes right now. Like, soccer? What? And again, we'll wrap on this. Are they going to live stream the trial? No. We expect the answer to this question to be no. Because it's judicial policy in Idaho. But there's a camera in there, like this camera that you're looking at right there. So there's a camera allowed. So we can stream the court feed when court is not in session. So would that mean nighttime coverage? that would mean that would be rough. But if you write to WFLA and you request it, we will very much, I can assure you, with the powers that be here at WFLA, that will be very much taken under advisement. I mean it. I'm not just saying that. Those emails do go a long way. And so what I mean by that, okay, so let's just say it happens in October, okay? Let's say that the trial actually happens in October. It's in the Pacific time zone. So if they start that day, every day at 9 a.m., that means that it begins noon Eastern. They would probably wrap up every day around 5 o'clock Pacific time, which means 8 o'clock Eastern. That's when we would start our coverage. We would then wrap up. I'm trying to just do the math in my head. So we would be done way into the night. I'm struggling to do the math right now in my head, but I mean, it would be overnight. Now to folks joining us elsewhere in the world internationally, you're probably thinking, it's not too bad. That sounds good, but that is a long time waiting for. And here's the thing: by the time that we would begin our streaming coverage, which would be about 8 o'clock Eastern, all of the events of the day will have already been tweeted out and shared. So at that point, people are just going to want the clippable moments. Now, some people are going to want to watch every moment of this trial. I get that. But the court policy and also as well, our time zone difference here in Tampa makes it very unique for us it's a very unique challenge, rather. It's challenging in a unique way for us to cover. Does that make sense, everybody? Give me a thumbs up if you're able to follow my little explanation as to why this is going to be really a challenging one. But WFLA is located in Tampa. To David, who just asked. I've done a lot of coverage on stream. That would be a new obstacle for me. But that's going to wrap it up here. If you want to request that coverage, you absolutely can, by all means. And you send it to news@wfla.com. If you want to send it, and our moderators are sharing some emails, so I want to pass this along so that we're all straight, because there's technically 3 emails. The first one is news@wfla.com. That goes to basically the quote-unquote powers that be. If you want to reach the people above me, the decision makers here at WFLA, the ones who dictate our coverage and what stories we stream and how often we stream and what time we stream, and if you want to make a news suggestion, send it to news@wfla.com. If you want to reach our entire team of streaming, just our streamers, that's WFLA now at WFLA.com. Sorry for all the emails, but our moderators will make this more simple. So again, the streaming department, which includes me, is WFLA now at WFLA.com. And then if you're just trying to get a hold of me and me only, just a direct email to me, it's heyjb@WFLA.com. So hopefully that makes sense. Hopefully that helps. Folks, thanks for joining us here in the WFLA Now Stream Center. Some new graphics as well. I don't know if anybody else caught that. So a little bit of a new look. Hope everybody enjoys the new look. There's more things to share with some of the progress that we're making here in the Stream Center. Big shout out to my buddy Salil, who helped me integrate these new graphics. Yeah, definitely really cool. On the like different animations here. See that again? Like there's that, and then when we go to the stream center shot, the slider cam shot, it does this. That was actually me making the sound effect. That was not the actual sound effect, but you get the point, folks. Hope everybody enjoys it. We will, of course, be doing more live streams on what is unfolding in Idaho in the Bryan Kohberger trial in the deaths of Ethan, Xana, Maddie, and Kaylee. We're coming up on the 1 year anniversary of their deaths, of their murders. So, always being very not far from our minds are the victims or the families of those victims, and the victims themselves. And we will have more coverage on this story in the many, many weeks and many, many months ahead. Thanks so much for joining us from the Stream Center, wherever in the world. Drop us in the comment section as we end out here one last time, because I'm going to look. Drop in the comment section where you're watching from. And as always, see you on stream. Thanks so much for joining us here on WFLA Now.